well, first of all, how do we spot a rent charge? Well, the first thing is that we've got an annual or other periodic sum charged on land. So it's quite wide-ranging in scope. Any annual or other periodic sum charged on land. The important point here to note is that when we talk about it being charged on land, we're not talking about mortgages. I was reading some case law just recently where a judge at first instance got terribly confused with rent charges and seemed to think that a rent charge was some type of legal charge, which it isn't, of course. It's an interest in land entirely separate from legal charges. The purpose of a rent charge is to create an obligation binding on the land, usually freehold, but it doesn't necessarily have to be the case, compelling the landowner to pay a periodic sum to the rent owner. Historically used because houses would be sold, and instead of selling at the capital value or market value, they would be discounted, and the seller would receive an income, an indefinite income, in connection with the balance. That's why you get old rent charges with a requirement to pay £2 a year or £3 a year, on the basis that in 1840 or 1850 or in the 1920s, that amount would be a considerable amount of money each year that would be an income for the developer or builder and would assist the buyer on the basis that they'd get a discounted property on initial purchase. These days, what we're seeing is rent charges being used for other purposes I've just mentioned. The Rentcharges Act 1977 provides that the rent charge is an annual or other periodic sum charged on or issuing out of land, except rent reserved by a lease or tenancy or any sum payable by interest. So again, we're talking about wide-ranging things. And the first thing that worries me with regard to this definition is, let's just have a think about it. If we've got anything that is akin to a service charge in a freehold sale, then that potentially is going to be caught by a rent charge. If we've got anything that isn't described as a service charge within a lease that falls within the category that we've just described, but isn't service charge, then again, that's going to be a rent charge too. So we're going to see rent charges in freeholds predominantly. We're also going to see potential problems with regard to leases and shared ownership leases. All potentially could have payments within them that are going to be rent charges and that have, as a consequence, some significant issues for practitioners. So the next thing is, how do you spot a rent charge? Well, that's the difficult question, isn't it? Could be on freehold or leasehold. A rent charge could be legal or equitable, but is an annual payment or periodic sum charged on the land. As far as a legal or equitable rent charge is concerned, it will require protection on the land register by notice. And here's the first point that I think might help us distinguish between a rent charge and some other form of payment. If we had a situation where there is a claim for payment within a transfer or within a lease, and that payment is protected by a restriction rather than notice, then I would contend that that would be an indicator that this is not a rent charge, but is some other form of payment. Now, it's not right to think that just because it's protected by a restriction, it can definitely not be a rent charge. I just think that it is less likely to be a rent charge as a consequence. Rent charges should, courtesy of the Land Registration Act 2002, be protected by notice on the rent payer's title. The next question that I posed, remember, was, what can I do if I'm buying property that's subject to a rent charge, either an ordinary rent charge or an estate rent charge?